Well, hello, welcome. Welcome to today's webinar, a judicial review of antitrust law matters on both sides of the Atlantic. My name is James Wood. I'm an editor at the Legal 500. And today we are delighted to be partnering with Elig Gurkainak, attorneys at law. We'll be hearing from Gonench Gurkainak, founding partner of Elig and one of the most decorated and revered lawyers in all of Europe. I'll just give him a brief introduction as he'll be moderating the session today. So Gonench not only founded Elig, but also heads the firm's competition law and regulatory department, which is a rather large department too, nearly 50 lawyers, I believe. You can correct me in a second if I'm wrong there, Gonench. But anyway, there's no better person to lead this discussion. Gonench has unparalleled expertise in both Turkish and international competition law issues and a vast experience of working with multinational and leading domestic companies, and indeed a long and successful record of handling the defense for clients involved in Turkish Competition Authority investigations, antitrust cases, merger clearances, and related Turkish and European Commission competition law matters.
You learned it all from me.
Exactly. In a minute, I will be saying, well, you know, unparalleled. I don't know about that in the presence of these people. But yeah, please carry on. Carry on. Fair enough. Fair enough.
Well, before founding Elig, Gonench spent more than 8 years at an international law firm working in its its Istanbul, New York, and Brussels offices. I'm sure he spent a fair bit of time in London as well. So a great person to moderate the discussion. I will introduce our two panelists today as well. We will also be have the pleasure and honor of hearing from Douglas H. Ginsburg, who is a senior circuit judge of the US Court of Appeals for the District of Columbia Circuit and a professor of law at GMU Antonin Scalia Law. Judge Ginsburg was appointed to the United States Court of Appeals for the District of Columbia in 1986 and has since led a long and distinguished career that has covered everything from serving as a professor at the Harvard Law School, acting as Assistant Attorney General for the Antitrust Division of the Department of Justice and Regulatory Affairs, Assistant Attorney General for the Antitrust Division of the Department of Justice, and a separate job, the Administrator of the Office of Information and Regulatory Affairs in the Office of Management and Budget, so two very senior positions. He has also taught at prestigious law schools, including Chicago Law School, New York University School of Law, and indeed his current role at Antonin Scalia Law School, George Mason University in Virginia. I hope I've not butchered that too much, Judge Ginsburg.
You've done well.
There's a lot I've missed off.
You've done honorably. It's not an easy feat. He has done a lot.
Yes. He's finding what's in it. And we will also be hearing from Ian Forrester QC, who's a member of the General Court of the European Union in Luxembourg and a former judge of the EU General Court. Ian was educated and trained in Scotland, you will be able to detect from his accent shortly, but also Louisiana, New York, and Brussels. He is very well.
I hear your Louisiana accent.
Oysters for that.
He is a well-known practitioner in the field of European law, specializing in competition, intellectual property, customs, anti-dumping, pharmaceutical regulation, football, and a range of other fields of expertise. In 2015, he was nominated by the United Kingdom to be the judge from the UK on the General Court of the European Union, where he sat on about 200 cases concerning a variety of European Union questions. He has also been an arbitrator in proceedings under the auspices of the International Chamber of Commerce, the International Centre for the Settlement of Investment Disputes, and the Court of Arbitration for Sport. In addition to that, he has argued dozens of cases before courts in several European countries. Again, Ian, apologies if I'm missing off any crucial information there, but I'll hand over to Gonench now and give you all a chance to fill in the gaps.
Thank you, James. Much appreciated. I truly need to say that in the presence of antitrust giants such as Ian and Doug, I don't think my expertise would be anywhere near unparalleled. It's very, very true that Ian is directly one of my teachers and masters as well. I've learned pretty much what I know from him and some other colleagues that also have learned from him. So, and Doug is a teacher to very many competition lawyers, and also decisions taken by these very distinguished judges have provided a path to a lot of competition lawyers. Without further ado, I'd like to jump into the matter of judicial review of antitrust law matters at both sides of the Atlantic. And the question is age. How do you feel about the impact of age, basically, in terms of the particular individuals molding the law and bringing about the law? Could they be younger in could they be younger in the EU? Could they be interjecting more of young influence in the EU? Is what I would like to ask.
Now that's interesting.
Yeah, that's a question I wanted to ask to both of you. Is there a point where you feel, you know, the Commission is having more of an influence on the making of competition law, and you see younger people chiming in with newer theories, whereas there is more of an influence in the US?
Goodness. Well, that's a tricky one. Before going to court to plead a case, of course, you try to think of what unexpected questions will come from the interrogators. And usually I was not surprised, but age is not one that I'd expected, but it's an interesting question. There are, in antitrust law and competition law, there are the grand old giants. And I'm writing an article at the moment and doing a bit of reminiscing and recollecting in the early days when I'd started practicing in Brussels. There were folk like Dr. Johannes, Michel Welbroek, Jeremy Lever, and other elders and betters who were big forces. And if you were up against Jeremy Lever, you had to be, or Michel Welbroek, or the others, had to be very well prepared because they were both courteous and intellectually they took no prisoners. And then as competition law has got bigger and wider and spread to different fields, competition law is being applied in areas which would not have been expected, had not technically been dreamed of 30 years ago. It is the case that youth is flourishing as happily as it should. In the courts, I suppose it's true that the judges come from 28 until Brexit 27 member states. So they come from very, very different traditions. And it's probably true to say that the younger nominees you'd find in the General Court and the older ones in the Court of Justice, I guess. Though I'd have to say I don't see a cleavage between young Turks and old silverbacks when it comes to arguing about the writing of a judgment.
Perfect. The reason, let me give you a bit of context as well before switching to Doug for the response of the same question. The reason for the question is that we did a poll and we looked for what would you like to ask these two individuals, and maybe it was because a lot of university students were involved as well. The main question emerged as one question that they wanted to ask was, is there seeing that, you know, you have to collect a lot of experience and information and everything, is there a risk that the more senior people being in the decision-making mechanisms, excluding younger theories or younger people from the process? Also, there was a more technical spin on it in a few of the maybe 10, 12 of these questions, where some people anticipated that maybe Europe is ahead of the US on that. because the Commission is interjecting itself in the making of the law, and there are a lot of young people in the European Commission, whereas the US doesn't have the same source either. So it's an interesting bit, I think. And
Well,
I don't know if you wanted to add something on that, Ian, as well.
Yes, let me comment. If the proposition is the people in their 30s who are leading a competition case on either side, that's the reason that Europe has a more radical tradition in the past 20 years than the United States. I would disagree with that explanation, but I would agree definitely that Europe has been, or Brussels has been a more radical focus, theater for the development of new and interesting competition law theories. And that's not because of youth, although I'm not opposed to youth. It's because of the procedural structures which attend European law.
Interesting. Yep. Doug, do you want to chime in on any of this, or would you like me to proceed?
It's an interesting question, and I'm glad that, unlike Ian, I had a couple of moments to think about it. Courtesy of Ian. It is not unusual for our two antitrust agencies to be headed by relatively young people. When I came to the Antitrust Division from Harvard, I was 39 as a deputy. I became the head of the Antitrust Division when I was 40. And by the way, my successor was younger than I. He had been my deputy and he succeeded me in the next administration. Right now at the Federal Trade Commission, the chairman is Lena Khan, is a little less than 5 years out of law school. Now that is unusual, measured that way. I'm not sure of her age, but just being only 5 years out of law school is, I think, very unusual. But apart from the appointments at the heads of the antitrust agencies, the courts as well have something of an infusion of youthful influence because of the law clerks. And pardon me, the law clerks provide, they are usually within 0 to 3 years out of law school, not always, but usually. And the law clerks serve as something of a transmission belt for ideas coming from the academy into the courts and potentially into the decisions of the courts. And I can give you a very concrete example that relates to the Microsoft case that we had 20 years ago. My clerk in that case had studied with a very distinguished economist, antitrust, industrial organization economist at the University of Virginia. She was recommended to me when she was a student at the Harvard Law School by the, at that point, I think, only economist on the Harvard Law faculty. And after a year at a law firm, came to me, and there was one problem in that case that had to be dealt with. And frankly, it was dealt with in the way no court had done before, but in exactly the way that this professor at the University of Virginia had proposed. I would not have known about that. It was not in a published document. It was in his teachings. Now, that's a very concrete example, but I see outcroppings in the opinions, even of the Supreme Court, of language, of terminology that is clearly that of a young person. You see a 70 or 75-year-old judge writing an opinion with using a few terms that you never would have seen 5 years ago, but that I know come from the law clerks coming in. Now, how much of influence that is, I don't know. In my case, it was a godsend.
Interesting. Thank you. Question to both of you again on timing of judicial review. So on both sides of the Atlantic, do you find that a new approach to how judicial review should work is necessary, and one should start thinking about it? Because it seems things are progressing very slowly in terms of once the judicial review is over and the decisions of authorities are now final, it is a whole different world. If they get reversed, it's also a whole different world already by the time it gets reversed. This is a common problem everywhere in all countries as well. It doesn't belong to your courts only. But for judges of your caliber to speak about timing would be important, I think. We were chatting with Ian the other day, and he was remembering that the bidding war in Intel was happening in 2005. Well, the decision is adopted in 2022, 17 years. Can you mold real life meaningfully with 17-year intervals? Should there be reform in Brussels or reform in Luxembourg, or overall a whole different approach to how judicial review should work? Whoever wants to take the question of timing on with any proposals of how to deal with the issue, basically.
Well, the situation is quite different, very different between Brussels, Luxembourg, and DC. And when I was in private practice, I used to criticize the structures with which competition law was enforced by the European Commission and reviewed. And my views have changed a bit from being on the court. But it remains the case that there is a big structural problem, and that is the General Court receives at first instance appeals against enormous decisions which are taken by the European Commission. And because the Commission wants to be cautious, it doesn't want to be reversed, and it doesn't want to be criticized for not covering every single possible point. That's understandable, but the remedy is a very burdensome one, and that is that decisions include literally hundreds of pages, some of them devoted to quite trivial matters which didn't really have a big effect upon the decision maker, but which are included so that no one can say they didn't give attention to coal being an alternative to elastoplast. Now, that means that decisions emerging from Brussels are desperately long, and that judgments coming from the General Court are also desperately long. And everything has to be translated through French into the language of the case, and that adds further months at different stages. So the enormous delays which we see in some cases are a very, very grave problem, because, as Gernich has said, what's the point of deciding whether in the bidding war of 2005 there was abusive conduct, making that decision on appeal and back and we know Intel was an extraordinary case. I was involved in it, but that's the extreme. But even if it weren't extreme, we're talking about years, and that is too long, especially in fast-moving marketplaces. And what do you do if someone comes and says, "I'm bleeding to death, you must help"? I think a possible solution is interim measures taken by the Commission. In other words, provisional assessments of the problem and a solution are a rough and ready remedy. And that can be appealed, and they are appealed, and they're heard in a shorter time. Because, and this is my last point on this subject, the General Court has got competence to review the acts of community institutions. Now, some of those acts came to the General Court at third instance For example, trademarks. If you ask for a trademark, you don't get what you want. You can have it reviewed, and then there's a board of appeal. And then once it comes as an appeal to Luxembourg, you have a well-focused presentation of legal questions against a particular factual background. But when the court comes to a case about Google or a case about Microsoft, it's hugely difficult to get a grip on it and produce an answer which is brief enough to be useful and brief enough to sustain judicial review to the Court of Justice. So I'm saying at great length, delay is a serious problem, and our current structures need a refresh.
Doug?
Yeah, well, we have a problem, but it's quite different from the one Ian has described in Europe.
Yeah.
We do not have a problem of decisions being issued in a prompt manner. Agency decisions are reviewed, if review is sought, usually within 12 to 15 months in the court. But there's a particular problem with merger law. In the mid-1970s, the Congress passed two statutes, the Hart-Scott-Rodino Hart-Scott-Rodino Act and the repeal of the Expediting Act. So what the result was, it used to be that most of the merger cases brought in the US by the government were brought after the consummation of the merger, sometimes quite a bit after. And this was true, this was quite evident in the 1960s when the court was taking so many merger cases. The two statutes worked a different regime. In order to expedite agency decisions, companies would be required to submit prior to consummating their merger, submit their data to the agencies and be subject to pre-consummation challenge. And post-consummation challenge became very rare. Not impossible by any means, but very rare. At the same time, the repeal of the Antitrust Expediting Act occurred, and that was an act under which, if the government was seeking an injunction in an antitrust case, it was heard in the first instance by a 3-judge trial court with a right of appeal, not a petition for certiorari, a right of appeal to the Supreme Court. And when that was repealed, the result has been that there has not been a single decision of the Supreme Court on a substantive merger issue since 1974, because without the Expediting Act, it's not possible to keep the merger together for 2 or 3 years to go through all all 3 levels of the court system. And so that's left us with a conundrum. We have the Supreme Court precedents from the 1960s and early 70s. And since then, everything we know about industrial organization, economics, and of mergers has changed. In the interim, the lower courts were left to figure out ways to deal with those changes, notwithstanding the precedents. The main Supreme Court precedent was that if the merger would result in a more than 30% market share, it was presumptively unlawful. With exceptions that the Supreme Court mentioned, one of which became the usual one for lower courts to avoid the presumption, and that was that if the market shares did not accurately reflect the state of competition in the affected market. So to some extent, courts have been using that way out, as it were, from the presumption. There are some other less important exceptions. Now we have people staffing heading both of our antitrust agencies, who would, I think, based on their what we know from their views, would not be unhappy at all. Would be quite delighted to have the reigning precedents from the 1960s and 70s be again applied literally. And we're all waiting to see what happens. Will the agencies bring merger cases, rely upon those old precedents and say, look, this is Supreme Court precedents. You really can't avoid them. That's yet to be seen, but it won't be terribly long. Now on interim measures, which I think are very dangerous. I mean, it has to be in quite a special situation, I think, to justify interim measures. The equivalent here, I think, would be a decision of not of the agency, but of the first instance court. Bear in mind that our Antitrust Division, Department of Justice, has to go to court to enforce anything, to bring a case, whereas the Federal Trade Commission has an internal tribunal, and decisions from that can be appealed to the courts. So the equivalent there would be a stay pending appeal. The companies companies have lost in the first instance court, and they seek a stay of the order of the judgment pending their appeal, and those are they're granted when the appellate process would, when the interim would really be destructive. But one notorious case in which that did not happen, by the way, I'll give you an example. That was Qualcomm. In Qualcomm, the district court ruled in favor of the Federal Trade Commission against the company, and it refused to stay the order. The Court of Appeals stayed the order, and eventually it was reversed when the court heard the appeal. So it was a good thing that that interim measure, if you will, if the effect of the decision below was stayed. In the LinkedIn case, a matter brought in a district court in California, private matter, the relief sought was access to LinkedIn's data to facilitate the competition coming from the plaintiff in that case. And the district court ordered that LinkedIn to comply with its order of giving access to the data, and there was no interim relief. So that order was immediately effective. It was later reversed by the Ninth Circuit Court of Appeals, but the data were out. There was no way to recall the data. And so I'm not sure how much, but some substantial harm may have occurred as a result of an order that was ultimately determined to be mistaken. So I think judicious use of anything of interim nature is extremely important, and not be overused, but to be used where there's a potential for real harm in the interim.
Interesting. Thank you. Going back to Ian and following up on this timing matter, I'd like to ask if the fact that you get European Union, the Commission decisions in 2-3 days. Sorry, hang on one second. Yeah, I'm getting a lot of background noise. So, sorry for that. So I was asking, decisions that can be taken in that can be read in 2-3 days, hundreds of pages of decisions. Could that be also part of the timing problem? And is there an advantage, Ian, do you think, knowing also the US law so well in the US, especially if matters go to a jury? Do you feel that there might be an efficiency in there?
Gosh. Yes, that's a very, very rich question. Let me begin at the end. When I was a practitioner, I looked I somewhat disparaged the notion of juries grappling with complex civil cases. Civil juries existed in Scotland for quite a long time, and there was a general feeling, oh, we don't really need them. However, my experience of being involved in teams arguing before a federal district court with a jury trial I have been astonished by the utility of the focusing of the key questions as framed by the district judge to the jury, with, of course, the involvement of parties on both sides. But with 10 questions, 12 questions, really the essence of the case was, in my experience, boiled down and presented to the jury in an excellently efficient manner. And the jury agreed with the line I was arguing. So that's one observation which supports my proposition that there's far too much material in commission decisions that arrive in the general court. Now, one way of solving that is not to be so wordy, but that risks the institution being accused of not being complete enough. I was involved in McGill about compulsory compulsory license of copyright material. And there, the decision was, I think, something like 11 pages long. And the judgment from the General Court, Court of First Instance, was, I don't know, dozens of paragraphs. And from the Court of Justice, the key language was contained in three or four paragraphs. So if I were in charge, which I'm not, I would make changes in Brussels in the procedures that lead up to the adoption of a decision. And I would give more power to, for example, the hearing officer, and make that a proper fact-finding process where two sides, one from the European Commission, one from the accused party, and listen to the intervening parties, where there was a question about whether there is, for example, I remember in the Microsoft case, was it the case that space on personal computers was so limited that people would install only one media player? And one side said, yes, space is limited, memory is limited, and the other side, no, memory is maybe almost unlimited. Now, that's a factual question, and I think it could have been settled, doesn't need a court, and that would then make the decision that's taken leaner by not making weak arguments. So I do think that delay is linked to the way in which decisions are written, and decisions are written in function of how decisions procedurally are conducted in Brussels. And I don't think that's irremediable, but I think it does need addressing. And a separate point I would make is that one of the reasons that American antitrust law is at civil litigation level, what we call private enforcement, quite conservative, in that in order to make an argument, the plaintiff has to convince a perhaps skeptical but certainly cautious federal judge that he's on the right lines, or she is. Now, in Brussels, young, radical, brilliant ideas don't need to survive the crusty attention of a possibly conservative judge. And so that's one of the reasons that for the past 15 to 20 years, the European Commission in Brussels has been the address to visit if you have a worldwide problem and you have to choose between Federal District Court in California and the European Commission in Brussels. There is not the crusty old judge, although I'm all in favor of crusty old judges, standing, looking at the law and acting possibly, as a brake upon legal innovation.
Thank you, Ian. Doug, would you like to also address the matter of what needs to be reviewed, being a function of the work product coming in, and the sharper it is, the easier the judicial review is. Also, when you're putting a question to the jury, obviously you have to sharpen it so that the jury understands it, and in the process, could you be rendering the overall judicial review process more efficient?
Well, first to begin, we don't have quite the problem of agency decisions coming to us that are unduly prolix and deal with too many issues. The Supreme Court has described the Sherman Act, our basic antitrust law, in an oxymoronic but I think thoughtful way, as a common law statute. And in fact, the way we proceed in antitrust cases is in the fashion of the common law. And so novelty is therefore suspect. Novelty is in the dock, and anyone proposing a novel theory has an uphill climb in the first instance, as well as the second. That is, as Ian said, a conservative approach, and I think it suffuses our procedure, simply because as a common law development, things go through very small incremental steps, which requires repeated litigation in order to shape a new decision, new theory. Just a judge on the Third Circuit Court of Appeals in Philadelphia some years ago said, I think quite correctly, judges are wary of grand methodologies and systems. And I think they should be. To give you a concrete example, the Arita Turner, that's the major long prevailing treatise in the US on antitrust, and with good reason, the Arita Turner treatment of predatory pricing, which involved determining what is the cost baseline below which one cannot go lawfully, was cited and discussed favorably in perhaps 5 or 6 of our 11 courts of appeals. Not one of them adopted it as the law of the circuit. Not one. They always took it into consideration, because that really would have been a major step. And I could see the Supreme Court doing that if a lot of the lower courts have already considered the idea. But it's terribly important, I think, that we not adopt wholesale revisions of our understanding or adopt novel theories unless they're tested empirically. And the role of economics now in antitrust law and shaping it really depends upon to a degree, the literature, the economic literature. Now, it is not possible to adopt everything that comes along from the most recent quarterly issue of the Journal of Industrial Organization. But it is possible for it to be cited by the parties, to be discussed and debated and resolved in some way in a court decision, but only after, and not accepted until it's been replicated and becomes more or less the almost consensus in the economics field, because otherwise it's subject to revision next quarter. We really can't have the law dependent upon that kind of volatility.
Very interesting. Thank you. Could we, Ian, say that? Yes, please. Please go ahead.
Comment?
Yeah,
as Doug was speaking, that made me think of something which, well, from time to time, people say, "What should I'm doing competition law and I want to do a PhD. Are there any good subjects?" And one subject which I used to think, I guess I still think, that would be interesting to pursue is a contrast between the decisions of the General Court in competition matters and decisions of the Court of Justice. Now, the reason that they're different is that the two courts are fulfilling different functions. When it's the General Court, it's judicial review, subject to the constraints of the treaty and the constraints of the Charter and the Human Rights Convention. In other words, you have to do a proper, thorough, Now, by contrast, when the Latvian Supreme Court asks the Court of Justice, we have a case and we're not sure which way to go. The supermarket has done a deal with the shopping mall whereby the supermarket will be the only supermarket in that mall. Is that anti-competitive? Is that contrary to the competition rules? And that question as posed, you can argue about it, but it's very clear what the question is. And the judgments of the Court of Justice have made new law in a number of cases, in a number of fields, in a way that's accessible and comprehensible, whereas the appellate role that we perform in the General Court sometimes hinders the clarification of the law. And so if you want to do a PhD looking at the differences between how the two courts approach big competition questions might be interesting.
Wonderful, thank you. I was going to ask you, Ian, again, a question that you might find interesting or provocative. This one is on me, though. It's not any poll or anything, so I take the blame for this one. And it was, I've always wondered, and we've had this chat in the past as well. So when I went back to Turkey, and when I was your apprentice for many years, you were already an extremely experienced independent attorney, having seen everything to be seen about all of the courts in Europe. But then you went to the court yourself, and I've always wondered if you were to pick one or two major disappointments, you know, really, is this how things work here? Kind of things. Obviously, you know, this is a public fora, we're recording it, but, you know, things that you feel would be helpful to practitioners, you know, any disillusionment that you may have had once you went there, what were they? Even when you were so experienced, you know, you felt, I hadn't seen that this was the inner workings of the court. Had I known, I would have, you know, structured my my lawyering in the following way, type of revelation.
Well, that's a big question. There are, I would say, frustrations which I expected and which were there. And one big frustration is language. And it's easy to say we should have English as an alternative working language. But there, you understand once you've been in the court for 2 months, you understand how complex it is to switch the language of a case. So I do think that it would be efficient if in occasional cases the procedures could be conducted in English language cases. I think that would speed things up, and it would make the dialogue between judges who speak, of course, good English, and the understanding of the technical terms. Language was an expected frustration or burden, and having been there for a short time, I understood better why it was a burden, and I understood that there is not an easy solution to that. That's one thing. Second is when you have to produce a judgment which is signed by all 3, all 5, all 15 judges, there's a no dissents. That has an effect on the law, which is not always good. And the law as made by our courts sometimes is too jerky. That's to say that, and you know, I've compared the Volvo Veng to McGill to IMS to Microsoft. Each of those is a compulsory license of intellectual property, but from the very beginning, in very rare circumstances, whoosh to the end, you couldn't be sure where it wouldn't be available. Those jerkinesses would be reduced if there were dissenting judgments. A dissent in a court of first instance can be a kind of marker, a kind of warning to the institution that you went quite far there and you didn't carry us all with you. So I thought I would emerge with a wish that there would be more dissenting judgments, or that there could be dissenting judgments, as there are in Strasbourg in the Human Rights Court. And I left thinking, yes, it would be good. And I also thought that we were, and I've said this publicly and other people have also, the referendaires with whom we work are fantastic. They know the law, exactly like Doug. The age range is different. There may be some who are straight out of law school, but there's also some in their 40s and 50s who are incredibly expert in the development of European law and have a range of knowledge of the judgments of the European courts far better than my own. So the fact that we are so well supported by expert younger people who see all the dimensions of the case and propose naturally texts to address those, I won't say unseen, less visible aspects of the case, less important aspects of the case. But that's another 2 or 3 pages, another 2 or 3 pages. That phenomenon makes for longer, more cautious judgments, which are difficult to digest. And I think that a judgment that emerges from our court should be capable of being read in a morning by a person of normal ability. But a 200-paragraph judgment to address a question of harassment in the workplace, it's not to denigrate the importance of dealing well with harassment in the workplace. It's emphasizing the importance of writing for the most important person in the room, and that's the person who's going to lose.
Interesting.
Garance, if I may,
please.
if I comment a bit. First to say that in our agencies, antitrust agencies, there is, of course, a great spread of age and experience. At the antitrust division, with which I'm more familiar, the entry-level position for lawyers, pardon me, is filled almost exclusively every year by clerks from the courts of appeals. It's a very desirable position for somebody who wants to be in the field. They have the option of becoming a lifer or going out into practice in the private world, private sector, after some years with valuable experience. So, but the agencies could not function nearly as well, I must say, without the people who have been there for 25 and 30 years as well. Yes. So there's this wide range of from novices to really fantastic civil servants.
Yes.
And the system depends upon both of those things, the entry level and the retention. As for Dissension, I too have long wondered and wondered why, and the courts did not, the European courts did not allow dissents. And this is now probably 10 years ago. I asked two people, one a judge on the Court of Justice and one a barrister in London, why the court does not allow dissents. And I got exactly the same answer from both of them. Might be 15 years ago. The union is too fragile. That was the answer. Now, you can see a case that's coming from one particular country, and there's a judge from that country, and it may feel quite strongly of a dissenting position, and that would make it more difficult for the judgment to be accepted in the country where it originates. Dissents here are, just as Ian said, informative. They may lay down a marker for a question that needs to be addressed by a higher court, but they have to be done, I think, very judiciously, appropriate for a judge, right? I remember my first year of law school in criminal law. The professor was actually from Australia, but he was admitted in the UK, saying that of a three-judge panel, dissenting is sometimes just a way of advertising the fact that you couldn't convince even one of your colleagues. And I've always kept that in mind. Now, when I came on the court 35 years ago, 1986, the court was not at all collegial. It was divisive and really fractious, and that was publicized too. And I later wrote some articles. One was called the DC Circuit en banc in the 1980s. It was next one was the DC Circuit en banc in the 90s. When the court was divisive, we had the full court revisiting panel decisions on average 6 times a year in the 80s. In the 90s, it was 3 times a year. In the first decade of this century, it was a little over once per year. Now that really reflects a great deal of trust among the judges. And as for dissents, I think there are 7 or 8% of our cases have a separate opinion, including concurrences. So there are fewer than that in dissents. There are terms of a year when I don't file a dissent. I've had 1 or so more often than 0, and rarely 2, if ever. So the dissents can be a reflection of dysfunction in a court. They can also be a tonic for surfacing important issues that need to be addressed.
Very interesting. Thank you. Ian?
Yeah, one special delightful feature of the court where I had the honor to sit is the diversity of nationality, culture, language, professional experience. The judges came from 27 other countries, and some people grew up under Stalin, speaking Russian as a first language. Another one was the secretary to the monarch. Another one had been a diplomat. Several had been professors of law. Some had been in the Ministry of Justice and had negotiated the terms of their country's accession to the European Union. And so, whereas in a law firm or a football team or an Anglican church, the experience of being engaged in a single enterprise as part of a collectivity shapes people. Of course, there's outliers and differences and so on. But when someone is named for a completely new job in a completely unique court at the age of 55 or 60, that person is definitely shaped by having been a diplomat for the country of Ruritania, or having taught at Ruritania's finest law school, or having been a minister. And so they come, shall we say, with their national identities quite strongly pronounced. And that is just fascinating. And so, whereas Doug has boring old Americans around the table all the time, I had the luxury of Cyprus, Lithuania, Spain, Austria, Italy sitting. And these individuals, highly intelligent, very skilled, very knowledgeable, each with referendaires who are more expert than the judges are in the details of the law. It was enormous fun to go through a case together and see what one would regard as important, the other would not. And it's a very collegiate place. Luxembourg is a very small city. It doubles in size each weekday with people crossing the frontier to work there. So it's very small, and the judges live kind of protected lives. Our parking spaces are supersized because it's assumed that judges will be careless and incompetent when parking their car. And indeed, you might say I am an example of that, needing a supersized space. So it was an absolutely extraordinary richness, and I can understand why people who are very, very well qualified decide when a referendaire, they'll not just spend 1 or 2 years, as is the norm in the United States. They'll continue because the atmosphere is so extraordinary.
Well,
Thank you so very much. Oh, go ahead, Doug.
Well, just to say about boring old Americans, the courts in the federal courts in the District of Columbia, Washington, are unlike, in some degree, unlike others, because the judges come from all over the country, and there's a great deal of diversity within this huge country. And so I've served with judges from California and Colorado and Louisiana and Illinois and New England and Pennsylvania and South Carolina and so on. And it does enrich the experience, I must say.
Yeah, no doubt. Well, thank you, both of you. I couldn't thank you enough. I have promised you 1 hour, and that we're going to end at the end of a sharp hour. We're at the end of a sharp hour, and I think we've covered really good grounds. It was a very candid, transparent account of comparisons. Thank you so very, very much. And I hope that the persons attending also found it useful. I'm seeing a lot of remarks and notes that they found this to be very helpful. Thank you very much, Doug, and thank you very, very much, Ian, to both of you. Thank you.
Thank you for getting us together. It's always a pleasure with you.
Yeah, this was absolutely fun. Thank you to James Wood and to Gönench.
Thank you very much.
Take care.
Thanks, guys.